I suggest maybe we could kick off now the session because it's almost 3:33. So welcome to this session on personalized computing experiences versus data minimization. I will give a first round of presentation on panelists today, and then, of course, let them handle this conversation. So if we can see the first slides presentation, please, on the screen, I will kick off and try to speak louder than the people in the other room. So basically, this is our panel today. I would like to introduce you with all the people that were crazy enough to delve into such a prospective issue, because of course this is something that we have as companies, as data subjects, as regulators to dig into already, would I say. But solution-making processes are not really well defined. So as a moderator, we will have the pleasure to hear about Vesela Gladicheva. So a long story short, I tried to pinpoint degrees and key characteristics of each speaker. So basically, Vesela has a master's degree in journalism. She covers European regulation in the telecoms IT, and measures the impact of European regulation, and basically has contributed to a number of UK magazines. Let's stress that she works in 4 languages, which makes it easier for everybody, and is a big fan of tennis, football, and Formula 1. As you can just guess from the outset, one key point in this presentation is to find how to keep a balance between personalized computing and personalized information disclosure on one hand, and on the other hand, what would be data minimization. So obviously, all the panelists that I sang played the game of disclosing some information that would be highly professional and directly in line with our discussion today, and then some more personal information. So first speaker will be Céline Deswart in e-privacy team, DG Connect, European Commission. And once again, let's have a look. She has a master's degree in European Union law, in public economy law, working for DG Connect since 2011. Working, and this is a big issue we're going to have to deal with during next month with the e-privacy directive. And then previously worked in the e-health unit. On the top of that, she's qualified as a barrister in France in 2005, and again speaks lots of really helpful languages. We will then delve into the issue having an EDPS insight, thanks to Mario Guglielmetti. So he started working in privacy as a lawyer in the Garante, the Italian DPA. And he also speaks somehow Latin. Omnia in tempore pondere mensura. The A is missing. Anyway, you will explain that to us later on. And then, once again, a PhD in administrative law, is a legal officer in the supervision and enforcement unit, and monitors, once again, data protection issues, which makes sense today. Previously worked for DG Justice and DG Transport and Energy, and delving, as we all have to do, into GDPR. Then we will have Jules Polonevsky speaking on behalf of Future of Privacy Forum, and on behalf of himself, of course, quoted as one of the top technology leaders in New York City by Crane's New York Business Magazine in 2001. His presentation, in short, would be graduating from New York University School of Law, working in the frame of the Future of Privacy Forum, and then previously being Chief Privacy Officer at AOL and Chief Privacy Officer at DoubleClick. Also a former Consumer Affairs Commissioner of New York City. He served also, a final point, in government at city, state, and federal levels, and notably speaks Hebrew. So it's really funny because when we were trying to find out some information that would be a little bit personalized, in the end we kind of had the same common approach on key points that would matter maybe in the frame of this panel. Finally, Jean Schulz-Melling, representing Facebook, an avid black and white photographer with old analog Leica cameras. This is really specific. Having a PhD in law at the University of Freiburg, point of contact on all privacy questions regarding Facebook, based in Dublin, and previously worked as a lawyer in a major law firm. Let's specify that it's been 15 years you've been working in privacy and that you are a member of the APP European Advisory Board. You're fluent in German and Irish. It was kind of a joke on my side because being based in Dublin, you tend to take the accent. Finally, myself, so I do work for Microsoft as the EMEA Privacy Director. So I just follow the tracks even if we don't really care. Co-leading AmCham EU on privacy. I'm also an active member of the IAPP, Women Leading Privacy Advisory Board. I was crazy enough to create, and if you dig online, something called EU Privacy Fall, which is a set of videos, like 7 minutes video each day on key topics regarding GDPR for non-experts, so that startup and SMEs would have a chance to understand what's been asked. New target for baby products online, and now speaking some languages, not knowing anymore if I do speak Italian. So basically, my special, profile would be potentially the kickoff. Do we need to share so much personalized information about ourselves? Is data minimization the best potential way to disclose data in each situation? For instance, today, what are the purposes of our panel? Obviously, speaking about data protection and new challenges regarding personalized computing online and new experiences. As you will see, all the panelists will address key problems, and without further delay, I will give them the floor for 10-12 minutes presentation before we have the discussion. Basically, what would be absolutely thrilling and ideal is that we have first the EU Commission, EDPS, kind of regulatory approach that would be made absolutely clear on your side, and then the industry or more business-oriented and practical approach. Once again, the key question being, how much data do I need to disclose for each specific purpose identified? Do we need to have control about each further use of data? For instance, some of the data I used today to present speakers were initially put online, disclosed by the person, herself or himself, and then in the end, further used for presenting as a panelist on this specific event. So the question that we will delve into is a prospective one. Thanks again for listening cautiously to the key point of each speaker, and most of all for participating to the discussion in the end. So now I will let EU Commission kick off.
Thank you, Marie-Charlotte, first for this very visual and very detailed presentation of myself. My intention is a bit to kick off the topic. So we know that innovation services are being created in order to serve people. They are intending to make their life easier. At the same time, we have seen the rise of business models that are based on personal data. Each time I go online, my personal data, information about my age, my marital status, income, the number of my kids, their age is being sold in milliseconds in order to provide me with tailored advertising. These business models are made on collecting as much data as possible on people, creating very detailed profiles. The more data available in a profile, the more valuable and interesting I am for tailored advertising. It is obvious from this statement that there is a clear imbalance of knowledge here. They know everything about me, whereas I have no clue about them. How did they collect my data, directly from me or from third party? This is called information asymmetry. Coming back to the paradigm that innovation needs to serve people, or more realistically respond to the demand, it is, I think, more and more crucial that innovative business models do not rely on invading people's privacy. This is particularly crucial when you see, for instance, millions of people in Europe, in the US, downloading ad blockers because they are annoyed about targeted advertising. Also, we have recent surveys in Europe, the Eurobarometer, that have shown that 60% of Europeans are worried about having no control over their data online. Around 70% of people are concerned about their information being used for another purpose than the initial purpose it was collected for. So as you can see, there are different expectations because on the one hand, you have current pushes for big data thirst, and on the other hand, you have a call for minimizing data in our privacy legal framework. So now I would like to focus more on our new legal framework, the GDPR. It's about enhancing individuals' privacy rights and putting them back into control so that it will restore the trust in the digital economy, which then will benefit the economy. So as for the key provision, one key point is data protection by design principle, which should help companies in order to comply. So innovation should take privacy into account from the start. Whether you are uncertain how it will apply, I think this is also a call for innovative business models. Then as for the question of the processing in itself, key principles of data minimization and purpose limitation need to be complied with. As you may be aware, these principles are not new, but they have been clearly enhanced. So what about data minimization? The principle is that you should collect only the data that are necessary for the purpose or purposes for which the data have been collected and which you have informed the data subject about. Moreover, I would like to stress that companies should think twice before collecting data that are not really necessary, in the sense that now they will be liable in case of personal data breaches, and they will have to notify them. So I would personally advise against it. So what is a better road? One road, of course, the best for privacy is the use of anonymous information as much as possible. So data rendered anonymous in such a way that the data subject cannot be identified anymore. Here, the data protection rules will not apply. If you are unsure also about this aspect, or also about how to enhance big data, you already have some guidance that exists from the Article 29 Work Party and also from the ICO in the UK. Of course, more guidance will come in the future, especially from the European Data Protection Board. We know that there is a clear call from the industry to understand better how the GDPR will work in practice, and the 2 years transition period that has been allocated to us is also about supporting compliance. The role of the Commission will be to work together with, closely with data protection authorities and the future EDPB in order to help this compliance. Then I'm coming back to the purpose limitation. So when you're collecting data, you need to first define very clearly the purpose of this collection so that individuals do understand why you need their data. This is also linked to the important question of consent when you rely on consent as a legal basis. So now consent has been enhanced. It should be informed, unambiguous, and freely given. So freely given means that you provide a real choice for users. And here I would like to emphasize the fact that contracts that impose handing over data that are not necessary to the provision of the services are and will continue to be illegal. Companies should provide the adequate information to their users. And this is linked to enhanced transparency in the GDPR. So users need to know about which data are being shared with third party, for what purposes, so that they can really decide whether they want the service or not. So this is also linked to stronger accountability that we can see in the GDPR. And here I would like to link with the IoT session that was earlier. So with new technologies, new challenges ahead, And in the GDPR, security has been enhanced, so data breach notification. So when you see IoT situation where they're dealing with personal data, the risks that is bringing that do not exist for the moment, like the example of the picture of the baby from this baby monitoring that is put online because of lack of security, you see that accountability is really important for privacy, especially with more personalized services. And so IoT is an important aspect. And then accountability is, of course, linked to stronger enforcement of these rules. So the GDPR do support stronger enforcement, which maybe was lacking, as well as dissuasive fines. So in my view, I think companies who play, who are willing to play by the rules will clearly benefit from the GDPR. How they should use privacy compliance as a competitive advantage. So they could distinguish themselves from less compliant companies. For instance, using privacy and data protection seals, the icons that have been deployed in the GDPR to clearly advertise their compliance with those strict privacy rules. Also, code of conduct should help, especially SMEs, in that aspect, and the Commission will support that. Privacy standards will, of course, play a key role. So to conclude, my feeling is that the argument that privacy impedes innovation is often overused. First, you need to really reflect whether, in order to be innovative, you actually need that amount of personal data to achieve it. Thank you for your attention.
So thanks again, Céline. And now Mario's turn.
Thank you. Thank you very much. Hello. Voilà. My point of view is the point of view of the enforcer. So it's a really on-the-ground experience. It's less political. But in a few words, if I can translate, if I can pass the message, the reply to the answer, how much data should the controller collect, should the private or the public collect, how much data as you want, how much processing should there be, how much data processing as you want and as you are aware of. The reply to this question is simple. That's why I see, voila, basically I see no clash, no dichotomy between data minimization and personalization. You can have the service personalized, you can have it customized, it's good, voila, it's innovative, it has advantages, but of course you should be aware of that, you should give consent to that, and the whole thing should be transparent. Now let me just invade for a few seconds something which is a bit about policy, but because I find this very complete. There's everything in it. You can find that data minimization is also a response to purpose limitation. It responds to proportionality, necessity. It responds to a logic of checks and balances. Voila, of putting really a measure, so let's say a limit, the right measure in the things in this ecosystem. And so we have Article 5 GDPR. More or less it's there, it's like the directive. Data minimization is even more detailed, even my perception reinforced than it was in the directive. The safeguards for us, for citizens, are there. So data must be adequate, relevant, limited to what is necessary. In relation to what? To the purposes. The purposes can be something which responds to a legal task, to a legal obligation, or to the consent which I've given, because I want a service to be given back, because I want also, yes, a service which can be understood in a broad way, but we'll speak about that. And then we do not only have the rule, we have the rule integrated in the product, in the service, when we have data protection by design and by default. So it's not enough to have the rule. When you have the product, when you have the service, incorporate it, put it in the process. Only personal data which are necessary applies to the amount of the data, the extent of the processing. Further processing, you send it to one broker, the data broker sends to another, only limited to what is necessary, to what is covered by the legal basis. To the amount, extent, period, data retention as an aspect of data minimization. If you store data too long, you don't need them anymore, or anyway, does not respond this conservation of data to the legal task or to the consent or to what the citizen expects, don't store them anymore, delete. And then, by default, personal data are not made accessible without individuals' intervention to an indefinite number of individuals. So it's very specific, it goes very far. And so basically, I simplify it. As an enforcer, we have a case landing on our desk. I have the case on my desk. It's a public authority I have to check. I simplify it because to pass the message. Of course, there are nuances, it's more complicated, there are coexistence of a model. What we look at for the first thing, the legal basis. Why the public administration is collecting this data? What is the legal obligation or task this legal entity is pursuing? On the basis of which law? Then I see, is this, voila, necessity of collecting data about you conveyed, communicated to you through a data protection notice, to an information, whatever? Is there a means which allows you to be aware of this going on? And then, of course, the whole thing comes back to the purpose. I, as a public administration, I cannot start asking, collecting data which are not related to the public service I want to provide. Of course, this is an example, access to documents. You want to access documents held by the European Commission. We are responsible as a DPS. The complaint comes to us because a citizen says the Commission is asking too much in order to have a reply to this access to document request. What is asking is just first name, surname. Let's speak about an individual, not a business company. The address, postal code, and yes, the document required. So in this case, very limited number of information required. Why? This seems a trivial case. It is not. Usually when someone asks for documents, let's be frank about it, is kind of exercising his democratic check. He wants to know for transparency reasons what's going on. So it's questioning somehow the authority. The authority, we tell the authority not to ask too much to this person. Why? Because it's a small thing, but multiplied for the number of requests already gives the importance of the issue, multiplied for the importance of the public actor at stake. It also gives another magnitude. We are there, why? We are there also to have a role as, let me say it's not an overstatement, also in terms of democracy. So data minimization also serves democracy. At the same time, if the administration, for example, EPSO, when asks for application, already starts from the very beginning to ask you a lot of documents, it's too much, they cannot process it, it's better if they wait the further step of the selection process. We are promoting good administration because we want it to be faster, quicker, and so on and so forth. So this is how it works in the public sector, basically. And this is our decision at the end. It was not an easy decision to say, yes, you can ask for the postal address. It seems a tiny thing, it's not. So we said, yes, you need legal certainty, okay. Are there other means? We said, we can ask ID card. No, this is too much. Keep it to the postal address. Why are you doing it? Verifying where the where request for access comes from. And so there was also an issue of shells, emails, sending thousands of requests for access as with the impersonator without real entity behind. So at the end, also this tiny requirement requires efforts on our sides. This I will skip, but maybe you can see, I can distribute the slides. There are more complex cases because there are information systems where there are national actors, there are commission, EU actors, and information system runs in such a way that there is kind of convergence between the information systems. So coordination with member states, with data protection authorities is needed. And a new project is the reference library online. You can go there, you can see all our cases more or less explained, really hands-on voila, and now it's the private sector. Here is different. Here, let's say we have consent, contract, legitimate interests. Of course, also when you are a public authority processing data, you can also ask for consent, voila. But usually, let's stick to what happens in most of the cases. For the private sector, voila, the basis is this: consent, contract, legitimate interest. Then we have the communication of what is going to be processed about you and how, and this happens to the data protection notice. Don't be formalistic about that. There is a lot of inventive here in the business world. You can find the best amazing solution in order to give immediate understanding to the citizens, to the users, to myself, when I go on social network, on voila, when I use these services online, in order to be aware immediately of what do they have about me. Before this presentation, Marie-Charlotte asked for, gave me a preview. This is what we are going to show about you. The picture, which I must say I was much younger in the picture than I am now, but was fine for me, so I accepted, expressed full consent about that, but now I'm revealing it. And for what purpose? Yes, because I have to show it. But what if she, of course, she would never have done it, but if she harvested the internet, found something, voila, a picture where, for example, I'm not in the best physical fittings and showed it here, voila, I could have objected to this and so on. So it was fully clear, fully understandable, all the flows were there, fine, lovely, and voila, we come back to the purpose. So 2 models basically. Again, and I think I've almost finished. So privacy information sharing. The business comes to you. Do you want this service? Do you want, I give you a special offer, I give you bonus. Yes, but what should I do? You give me the information about all the track of your purchases, and that's all. Okay, maybe I give my consent. But if the same company comes to me and says, soon after, not only I keep track, but I also sell this to third parties, would you still accept? Maybe in this case, I would say, no, I do not give consent. So it's all depending. So it is data minimization also in the context of customization, also in the context of personalization, but starts from you. And so this is a survey by US, very good survey. It says acceptable, depends, not acceptable. These all things depends on a number of factors you should be aware of. So data minimization here for trust. And I conclude, this was the last slide, data minimization for democracy, for good administration, for trust, for the fair balance. And you say here, but it's not a detail, and I finished, it depends also, the data, your willingness to sell your data, that's the way it is, also on your income. This means that if you put demand and offer, means that some data companies pay more for some data than for others. For the same kind of data, depending on the purchasing power of the person. This is also an issue we should think about. Thank you.
Thank you very much for having such a comprehensive approach of, the regulation, but also the regulatory challenges that you have to face every day, because it's not that easy to regulate, and knowing whether an address is enough and enforce. Okay, so enforce only. We have no DPA here, so let's have Jules now giving us an insight on something that might be a little more prospective and in the future of privacy.
So since personalization is a key part of this panel, I think one question is, what is personalization? Very often you see changes made in what is displayed to a user, and sometimes it obviously can be built based on tracking individual, but sometimes it can be based on other factors, right? I may go to a website, the website is about sports, I'm shown a sports website, right? The industry often doesn't think of that as personalization. Obviously, I'm not necessarily being singled out as an individual, but getting a different experience because I'm where I am. There are many companies that will do research, opt-in, consent-based research. Please let us understand. And now I learned that this sports site is really somehow mostly women, because when I did this small sampling, that's who I learned. And I learned when I asked those women questions that they're also BMW drivers. They're part of a research study. They informed, consent, they paid, they said, I want to contribute, right? And so I now have a detailed profile of the kinds of people who go to this site. And now, not only am I saying I may give a sports ad, I may say I'm giving a BMW ad to you, the new person who comes there. I know nothing about you, but I now know that the kinds of people who go to sports sites or who watch this sort of TV show are of this type. And again, I'm personalizing. So I think, again, let's take important steps, because they all have different issues in terms of whether I'm tracking an individual, in terms of is this aggregated, in terms of is this really personalized. And very often, it's blurred together in the media, or even if you read an article, it's not clear, or if you read a privacy policy, it's not clear. So today, is today the 28th? It's Data Privacy Day, yes? Today, tomorrow? I've been traveling. So tomorrow, okay, I think I can make this comment. It won't make such great news, and if it is, then it's important that it's big news. But the research industry is announcing tomorrow, so maybe we'll keep it off the record if there's any reporters, that all of the companies that do research, again, this is not the ad targeting and the tracking users, but who create panels, but then make available to the market, to the TV people, to the website developers, hey, the people who come to your site, here's what they are really like, so this is what you should show them in terms of your content or in terms of your advertising. Isomar and others, Nielsen and others like that, again, very often lumped together with different kinds of ad targeting, but it's a very different type of business, a very different type of privacy impact. They are also now creating a page called researchchoices.org, and so if you do not want personalization, even though it is not personalized for you, but based on what is known about people like you, they will point to the different ways that you can opt out of that. Okay, so that's one thing. We now know that we'll have a much more tight definition of de-identification under the GDPR, and so we'll have to think a little bit more when we think about personalization about singling out. Certainly many companies, many publishers have had the view, well, I'm not identifying somebody specifically, I'm just tailoring content, I'm tailoring ads, and there's been different soft law in different states where fine, that's okay, it's not okay, opt out, so forth, have a retention policy. Exactly where and how the bar has been elevated to understand how it does or doesn't affect any sort of personalization, I think is going to be very important. But here's the hard question, right? Because clearly if I ask you and I get full and informed consent, we know that it can be easy, hopefully, to comply with the data protection laws. The hard question then is, okay, when can I do this at all, if ever, without your permission? And are there cases, obviously we see today many, many cases where certain kinds of personalization is done without your permission. And some of the arguments that are made, I will tell you during my days as Chief Privacy Officer at AOL, we had a very bad problem where some hackers figured out a way to do a Microsoft Windows exploit that popped a message to people. And it was an advertising message. It was an ad to stop pop-ups, right? So these pop-ups were appearing. But the users thought that it was AOL because we were also giving often lots of pop-ups. And our CEO said, listen, we have to do better. No more pop-ups. We made a big announcement, no more pop-ups. And the next day, people start getting this gray pop-up. It's actually coming from their operating system. It was an exploit on Windows. But they were blaming us. And they're calling us, very expensive phone calls, while trying to figure out how to do this. And we would show them how to turn it off. And it kept happening and happening. So finally we start advertising to people, hey, is this happening to you? Do this, change this setting, and you will not have these pop-ups anymore bothering you. And people kept calling us and calling us and calling us. And so the technical people came to me and they said, you know what, we can push something out and turn this setting off on their computer. It's got nothing to do with AOL, but we can put this security patch on and they won't get these pop-ups. And I said, well, I don't know, we have to ask them. So we asked them, and they kept calling us on the phone. Why am I getting pop-ups? And we had, it's not us, can we help you? Take 10 minutes to show you how to turn this off. I said, do it. And we pushed it out to 30 million people at the time, and they stopped getting these pop-ups, and the business was happy, and the people were happy, and a few security and privacy people said, how did you turn it? You didn't ask me. I said, I asked them, They weren't acting, they weren't thinking, they just wanted someone to fix it for them. So there are times where we need to, for people's benefit, help them, even though it might mean changing a setting on the computer. How many of you have been on the web and like your browser crashes? And you got a little message from, let's take Mozilla, right? The not-for-profit, not the big company, a little more maybe socially, focused. Firefox crashed. Please send us some information de-identified to help improve the browser. Do you know how many people say yes to that? 3%. What, you don't want it not, you don't want them to fix this, that it shouldn't crash? They need to know what other junk is on your computer, what programs are not compatible that is causing this, right? Only 3% because so I ask people why. So it was in my way. I didn't want to think about it. I don't, it could slow me down, right? So again, when is it okay for me to assume some permission when it's good for you and when it's not? So those are maybe easy examples, I hope. Let's take a harder example. How many of you use the Facebook feed show everything, or how many of you leave the Facebook default, which is here's what we think you like because of your friends, right? And the research shows, and I kept saying, I want to choose. Don't want to miss anything. The research shows that the people who turn it to show everything start seeing all the stupid things that all your friends have shown you, including, some distant friends, some close friend, his lunch, his food, he broke up with his girlfriend, as opposed to the more interesting things. So people say, I want that one, and then they stop engaging as much because it turns out that they really don't, right? So Facebook decided, for better or worse, we're going to give what the statistics show is actually, at the end of the day, more interesting. And so here's the question. If I'm going to do personalization and I say to you, hey, choose. Okay, show me the personalization. Oh, there's nothing yet because I didn't yet track you to personalize. It can be very hard to make a choice. I can say no because I don't have the time, or it may not be interesting and valuable until I've done it. And then I can say, here's the personalized version, which has been personalized for you. Isn't that very interesting? Or here's the basic version, right? So one of the challenges is that many of the information society services rely on the network effect. It's only interesting when everybody is in there, and then all of a sudden, it can be interesting. So it can be hard to queue up to people, which one do you want, because you can't show them the two options until you've done one. So again, these are hard. Again, these are all solvable, but I think they're hard questions. I have a Wi-Fi scale, WeThings, a French company. It's an internet-connected scale. I have it tied to an app. And I get on in the morning, and it shows me my weight. That's what it did 2 years ago, right? About a year ago, it started showing me the weather. Oh, that's very nice. I don't even use the app anymore. I just get on. I like the fact that it's a nice scale. I don't sign into the app. I didn't update it. It's showing me the weather. Oh, that's very nice. I guess they updated it somehow. They didn't ask me. It's not personalized. It's just the weather from my area because they know my geography. They didn't ask me for my location. And then just a couple of weeks ago, I looked down again in my underwear. I don't want any extra pounds on there, so I'm standing there, in my bare feet and my underwear in the morning. I'm looking down, and it shows me the weight, it shows me the weather, and it shows me a little chart, unfortunately, with an arrow going up. What have I done over the past week? Because it turns out people are not going back to the app, and so the whole purpose of this is that it's charting, and it's showing me, unfortunately, that I'm not doing so very well. Again, they didn't ask me. I don't know how they would ask me, because it's my scale. Again, I don't think they did anything very intrusive, but again, they had to default on, and they're giving a personalized graph to me. I don't know what the Dutch DPA will do. We have a panel tomorrow on wearables. The decision in their Nike case said, you must specify each purpose because this is health data. I guess it's my weight, so maybe it's health data. My weight over time that I'm getting fatter is probably of medical interest. And the Dutch DPA's office said, no, each use needs to be very specifically consented. And so if I am agreeing to personalization, what is my specified purpose? Can we have a very general purpose? And in the world where we're going of artificial intelligence, where we're saying, machine, do what is good for me, do these many steps, and actually figure out some of these steps, what challenges will we have with specification of purpose? How narrow will it need to be under the new GDPR? especially when it's sensitive data. And the question is, what is sensitive data? Because it turns out everything is sensitive data, right? I can analyze all sorts of very interesting information that maybe didn't look like it was sensitive, but because of certain habits or purchases or so forth, we can end up learning things that are sensitive. And so how we carve the right lines that will leave the flexibility that is needed for the services that people want or may want, and balance that with, no, these are specific areas where we must make you stop, think about this, make a very clear, specified, and specific decision. Ethics is increasingly part of this equation because it can be hard to have a very specific debate over what is the legitimate use when some of these boundaries can be wide, and so it's perhaps ethical concepts that need to be incorporated. We have probably what we can learn from the academic community where one goes to an IRB in the US and other boards in Europe and elsewhere, where if I'm a researcher and I want to experiment on humans, I must go through an approval process. We need to consider the impact, the harms. What are you trying to do? Cure a disease? Okay, maybe we'll accept a little bit of risk because we recognize the societal benefit. So that's easy to do when we're thinking of the government sector or maybe, certain health sectors. But what do we do when we have, say, wearables or we have other companies who are incorporating this research? Uber hired the entire robotics department of, one of the leading universities to do the same work at Uber. So do we want this to be published where we can debate it and see it? What is the ethical framing? So anyway, we're in for a lot of complex and interesting issues, and we look forward to, I think, your questions now. Yes? Oh, no, we have one more celebrity.
So finally, we will have Facebook. Once again, clear presentation. I think regarding the topic, your insight is going to be really enriching.
Next celebrity. Thank you, Jules. Okay, let me start off by saying thank you for having me and giving us the opportunity to participate in the discussion. I think, personally, that we are living in very exciting times these days. Data is becoming something that is very closely connected to growth over so many industries and over so many sectors. I personally think that's very exciting. What I think, because we are talking about personalization in services, is the fact that we have this data relation actually makes services better. It makes them more relevant. It makes them, more individualized, and I think more valuable to the individual user. However, should I actually put these on here so that it's not the logo the whole time on the market here? Otherwise, people will start screaming that we use this here for advertising, and I don't want that. So I think there is a very important question that we all should face, and where I think we all are going to have a great time debating it. How can we, and I mean we, everybody who is a participant in this discussion, that includes the regulators, that includes the lawmakers, that includes every single individual who is using these services, and that includes the companies who are providing these services, how can we make sure that we set up something that allows both, talking with Anne Cavoukian's famous lines, that gives us a win-win situation, that gives us, on the one hand, the opportunity for growth, to make best use of all these fantastic opportunities that personal data can give us in terms of personalization of services, and on the other hand, do that sustainably. And what do I mean by sustainably? Obviously, we have a situation where we talk about personal data. Sustainably setting up these things and sustainably allowing for growth means taking into consideration the fundamental rights of the individuals whose data it is that is used for this personalization. And this is a very interesting, very complex question that has a number of different angles. And I can only, because we only have like the 10 minutes here, can only pinch down on one or two of them. One is the regulatory angle, as I would like to call it. We're living not only in exciting times because of all of the ongoing data, we also, as everybody knows in this room, living in very exciting times in terms of what is going to happen over the next 2 years and what is going to happen when the GDPR actually kicks in and rules our lives. So 2 words that I want to throw in and make good use of for the upcoming discussion afterwards: flexibility and risk orientation. Whoa. That's something that we all have been talking about, I guess, for the last decade, so I'll make this very short and very brief. I see flexibility with a crying and with a whining eye. The thing is, flexibility in the law makes it well usable, makes it usable and applicable in a way that allows for companies to develop new services and to participate in the growth in it. We have another description of flexibility in this case, which is flexibility in terms of 28 different member states doing different things and being very flexible about how they actually apply the GDPR. There is something to be said about a desired higher level of uniformization in a way. I guess we would all have loved to see the parties come out of the trilogues with an even more focused understanding of how European privacy should have been. I just put out here as an example the rule of the 16 to 13 range that we now have in terms of the possibility to actually provide consent. Basically, it requires parental consent for those under that particular age. The problem is the GDPR didn't actually give us that particular age. It gives the member states a span between 13 and 16, which you can imagine makes it difficult to actually set this up in a way that works and that it is still a good user experience at the same time. Another angle that I want to touch on briefly is what I called here the tools of the trade. So I think actually, because Marie-Charlotte, when we talked about it first, asked, okay, what are, under the given regulations, what can we do? What is there? What handicraft is there to be used to make all this possible? And I said, well, we are still governed by the directive, and the directive gives us certain things. But then again, I hope that with everything that is in the GDPR, that not just the companies are going to prepare over the next 2 years, but the regulators as well, and that they will start thinking and living the spirit of the GDPR a little sooner. 2 things or 3 things here. Privacy by design, it's something that we have in our minds since 1994, and again, it was somebody in Canada who came up with it, but I think I can tell here, if it is properly set up and if it's well thought through, it is a fantastic tool to make sure that potential privacy risks for the users are minimized as much as possible. GDPR will give us something that actually some companies already applied even before, which was then called privacy impact assessments, PIAs. Now everybody talks about data protection impact assessments, which is a longer acronym, but I'm trying to get used to DPIA. In the plural, it gets a little confusing, but these tools will force companies to sit down and think about these risk aspects at some point in time. And we know that the regulation gives us some framework around this, how this works. In certain cases, we'll have to go and consider these things with the DPAs. So I think this is another very strong tool that we'll see employed much, much more in the future. And the last thing, it's my favorite, which is still the strongest possible and the best possible user controls. Because at the end of the day, we are protecting individual data, personal data. It should be the user who is in control of things. And the better we can work controls, and we all know that this is an ongoing process where you don't do something and then you leave it there for the rest of the time. You actually make it better and better and better, at least you try to. So these are tools that we actually can apply today and that make, I think, a difference in terms of how we treat user risks. And the last thing I want to point out, yes, the role of the DPAs. We are all kind of looking to all kind of participants right now. That includes, obviously, the Commission, but that includes many other players as well, and obviously, most of all, the DPAs. I can only utter here a personal hope, and that is that we actually get to a status when everything has settled a little, because right now we have a lot of misunderstandings maybe going on, still a lot of uncertainty, what everybody's role will be and how this will all settle down. Once that's done, I personally hope very much, in the interest of every participant of this discussion, that we will have this, the predictable, the reliable, and the sustainable system that gets us what we need to know, that gives us guidance, that gives us the signals that we need to have in order to build products and new services that are in compliance with these new regulations. And the strong guidelines from DPAs will be essential So we very much hope that the DPAs pick up this responsibility, get together, cooperate on these things, and try as quickly as possible to give companies guidance on how to do these things right. Thank you.
So thank you, and once again, thanks to all the panelists because of being so personalized in their presentation, but also minimizing those presentations to 12 minutes maximum, so thank you. Now we will have the set of questions between panelists during 8 minutes, and then the floor would be yours.
Thank you, Marie-Charlotte. Hello, everyone. I thought these were very interesting remarks, and I think companies who are doing personalized online experiences and services will be very happy to hear what Mario said, that there is no clash between personalization and data minimization. I wanted to focus a little bit more on the recently agreed text on the general data protection regulation and the question of big data technologies. A lot of web services and retailers such as Amazon.com using big data to present a personalized set of services and products to their customers. But some EU lawmakers recently raised concerns and voiced concerns in relation to the agreed text, and it's actually not future-oriented when it comes to the use of big data technologies, and specifically Article 5 on data minimization. So it's just, and that might end up before the court. So I just wanted to see whether any of you had any thoughts about that.
So something I wanted to say that, I mean, in 10 minutes you cannot say everything. I know that companies are really concerned and we're in a situation of expectations regarding compliance, but we also have a tendency to forget that all the benefit that was brought by the GDPR for companies compared to the current situation. So I wanted at least to take that opportunity. So currently companies are dealing with 28 different legislations. If they are in several countries, they have to deal with different DPAs. They have to notify when they intend to do processing of data. So there is this also forum shopping of choice of DPAs, as was mentioned this morning by Mr. Albrecht. So I wanted to emphasize key points that will make it the situation for companies simpler. First of all, one single set of rules, although, as we have mentioned, it's a compromise, and in some specific areas, there are margin of maneuver for member states, so we'll need to see implementation. The fact of having to deal only with one single data protection authority, no need to notify anymore the processing, and you can, then it's being replaced by the data protection impact assessment if your activity provide risks to privacy. Then the risk-based approach that was mentioned by Facebook is also present, so that the balancing rules don't apply to everyone the same way, that you take into account the risks that your activities is undergoing to privacy. The fact that we are trying to have, the text is trying to be future-proof, promoting pseudonymization, and also the interest of data protection by design. So those are some important principles. And then as for big data in particular, there was support to research that was really important compared to the rest, is that the issue of further processing, there is this presumption in Article 5, 1b, that when you're processing data for another purpose, if you're doing it in the context of research, then your purpose is compatible by default, if I may say. So you don't really need to look for another legal basis. And then to come back on the point that was mentioned by Mr. Polonetsky about the issue of consent, it's also important to recall that consent is not the only legal basis that exists currently and in the GDPR. So you have other legal bases. and I think, for instance, of the legitimate interest of the data controller. So far, there is a balance with privacy. Also contracts. I mean, if what you're doing, like you were explaining the example of the scale, is for the purpose of providing a better service, I think you more or less can see it in the purpose from the beginning to foresee that. And then as for how to make user control easier, you also have the possibility, I mean, for data subject more and more, and I'm thinking of domotics, for instance, to have data subject that can have so user interface that are privacy friendly, where you can decide with whom you want to share data. So that was some points I wanted to share on that aspect.
So let me jump into that, because I think those are many of the key issues that I think are still not well delineated. What exactly is the boundary under the new formulations of legitimate interest? How wide is an incompatible use? Is it very tight, one new feature, or is it something broader? If I pseudonymize data and I can now have a bit of a risk assessment, who does that? Must I do a data protection impact assessment and go to my regulator? Is my regulator an expert on bioethics? The CNIL has had a very interesting approach, for instance, where they have a special, outside committee. A researcher comes and says, I'm going to, solve the global health problems of the world, but I must use data beyond certain parameters, incompatible, research, and so forth. And they get an opinion that includes experts in that area. We now have so many areas where research can be done by anybody and everybody, a graduate student, a company that is doing pure science. If I'm studying my wearable, is it company work because I want to make the wearable figure out how to make people exercise and be healthier, or is that business? Is it research? The parameters, I think, are going to be incredibly important, and I don't know that we fully understand yet whether they'll be read in a tight way, which could limit some of the uses of big data, or will they be read broader so that the true benefits, if regulators and policymakers with expert input believe that, look, this does have some risk, it is not directly aligned, so I can't rely on consent, but here's what I believe. And so where are we, do we have the capacity for those sorts of conversations? Are they going to be one by one, which probably doesn't help? We end up having a lot of soft law again, where nobody knows exactly what the boundaries are. Will there be, I think the EDPS's focus on ethics and maybe putting some granular ideas for how that fits in to some of these conversations will be very important. Is it not ethical to not study? Maybe my product is poisoning people or is making them very depressed. Maybe I must study and understand so that I know to fix problems, which if I don't do the research. So anyway, lots of really challenging issues, and would love to, yes.
Why not? Thank you very much. I simplify again. The deal must be evident, must be clear. The idea of fair deal. What are you getting to? Where are you going as a company or an individual collecting data, processing data? Are you doing it for a commercial purpose? Are you doing it for research purpose? Tell me the deal. The collectivity should be aware of where exactly are the conditions and limits and the purpose. Yes, and finish very soon of this. So basically, okay, we should distinguish the situation. We should not forget that personalization is very closely linked to profiling, that there is a face of heaven of customization and a face of hell. You can have, as a face of heaven, in a very rapid way, the services you want, the book of the same actor or the same, the video of the same actor or actress you preferred ready at your desk, and so on. At the same time, you can be profiled, for example, in a way you are not aware of, or just an example as cholesterol groups, and you cannot get an insurance, or you cannot get a job out of that. So beware also of personalization. It has this double face. face of heaven and face of hell. And remember, and let's stick every time to the purpose of the processing. If it's a research, probably it's a research which has been authorized, it's a health research at a scientific level and with certain safeguards and with the data protection authority involved and so on. So I would invite you not to mix different situations, the commercial, the public, and research. Thank you.
Can I reply maybe? So I was working on mobile health in my previous position in Connect, so I know the issue very well. I think what you emphasize is the fact that the GDPR applies to very different kind of data controllers, data processors. Some are big companies, others are app developers. And especially, I mean, in the field of health, it's difficult to know whether the data that you will collect with your app when you're an app developer will be truly health data, or they will be just well-being. So we were targeting that issue in the green paper on mobile health, and we also wanted to provide a bit more clarity with the staff working document that was trying to help. And then the follow-up to the green paper now is because we are aware that SMEs is much more difficult to comply with this specific issue of whether or not dealing with health data. The question is complicated by the fact that currently health data is defined in the member state in very different ways. For instance, in France, it does require that a doctor is involved. So you will say that in fact, most of the apps are not processing health data in France. So in this context, we have been promoting now a code of conduct on mobile health that should help this particular field in order to face the challenge of compliance in the sector. So
if I may, I saw that some people wanted to ask questions.
Yeah, I just have one question for Facebook, which is for clarification. Are you saying that you are deploying privacy by design methods?
Excuse me, I could...
Yeah. Are you using privacy by design at Facebook?
Yes, we are using privacy by design at Facebook.
Can you please explain in what way? Because to me, Facebook is public by default. So I can't understand how you can actually deploy privacy by design.
So privacy by design and privacy by default, in my opinion, are two different things. That's what you just said as well, so that's great. The privacy by design, in my idea, is integrating privacy into the whole process, from the very beginning to the very end.
You're talking about social privacy, right? Like I can hide from my friends, but I can't hide from Facebook and Facebook's paying partners. Is that kind of privacy, or? Because you're saying...
Maybe we're going to let him answer, like 2 minutes, and then you can answer back.
And the other thing is I have difficulties understanding here because somehow the sound doesn't really get well through. Yeah. But what I take is, and let me repeat that, I see it as two different things, privacy by default, privacy by design. Privacy by design is a majorly important thing in terms of developing new products, in order to develop new good services. You should start off in the very beginning, thinking about it, and we're talking here about data minimization, which still means as much as necessary and as little as possible. So you start at the very beginning thinking about what kinds of data do you need for the service, what should the purpose for this actually be, and you carry this through the whole development process until the very end, when it is about defining the description, writing the help center text, writing those little pieces that explain to the users how the product works and all these things. Privacy is, and I think this is the commonly acknowledged idea about privacy by design, it shouldn't be, like Anke Wukian defined it, not be put in the end and attached to it with glue, but it should actually be an integrated part of the whole processing. That's what I meant when I said. Does that help with the answer?
Yeah. Okay. So maybe we're going to have another question from the audience and one question by the moderator to close the topic.
Thank you. I'm Kjeld Herreman, I work at Worldline. This isn't specifically targeting Facebook, but just in general. There are a couple of very large companies sitting at the table, including Microsoft. One of the things that came up was in terms of consent. Can you hear what I'm saying?
I guess if you really hold it very close to your mouth, it works. It looks a little odd, I know, but right. it is sound technically better.
So one of the things that was mentioned was that in function of user consent, the user experience would be different, so that you'd have some controls yourself over what data can and can't be used. So that's, I think, something most people agree on. How do you feel about companies refusing service to people who refuse to give consent? Again, not targeting Facebook specifically here, but in Belgium, I think it was about a month ago, Facebook opted not to allow users to view public pages if they weren't logged into Facebook. So I'm imagining a world where if I don't give my consent to be profiled by Amazon, by Microsoft, by Facebook, I can't use any of those services. So my question is this: should companies be allowed to refuse service rather than not give a personalized service if users don't consent to being profiled?
So respecting the fact that it was not just addressed to me, but also to everybody else, let me just still take the lead. That situation was, in fact, not, or the background for this situation was not that you don't agree, you don't give your consent, and therefore you can't use the service. The background for that very unthankful situation is an ongoing court case where it basically is about a cookie that was placed, a security cookie, without which our security people said we have extreme difficulties elevating the level that we need in terms of information security to what we think is necessary. So without this cookie, certain pages weren't just viewable. So it's not about that question, we don't allow you to use the service because you didn't consent to us using information. So it's a very particular case in that one that has a very particular background too.
Can I frame the question maybe in a way that I see as different or logical? Obviously, there are services that you better give me information or you can't have it. I checked into the hotel. I can't say, hi, I'd like to be anonymous, please. No, we need to know information, billing, law enforcement, right? All sorts of things. You registered for the conference. I guess they could have said, this is an anonymous conference. We just pay us through Bitcoin or cash. They don't offer that option, right? You have to register. Okay, that's their right. We believe that's okay. Now, if their policy was, oh, and while you're here, there are some sponsors there. You don't want to see the sponsors because it's advertising. We'll give you some way to turn it off. No, the conference is funded by sponsors. Some people don't like that it's commercial. They say, okay, well, would you like to pay for the lunch or rent the space, right? So there are clearly some places where we all agree, look, this is data that is reasonably essential. And then, wait, maybe let's go a little further. I want to understand my website, how many people are coming. Maybe I want some of that information. Now, what about selling? What about very robust personalization? What are the range of primary uses that we think are fair, that are proportionate for the nature of the relationship, right? We usually understand that you're not likely to get a choice there. Maybe some leading player will say, okay, sites are now blocking people who block ads, right? And saying, that's very nice. Maybe Facebook or Google can afford it, but I'm a blogger. This is how I make a living. And then we debate that, right? We have people saying, no, it's my right. It's my computer. So I think the question really isn't, can you deny services to people who don't give you data or money or XYZ? Clearly you can. What is the range of things that they can do before you get to say, I want your service, I want the benefit, you're making enough money to do what you're doing, you don't need that extra enhancement, that extra personalization, and that, I think, is the harder question, and it's really going to be dependent on which service we're talking about.
And so giving one last question to the moderator and one last to the audience, so please, quick answers to those.
So I just had a question about this time poorly targeted personalization. And you emphasized the fact that personalization makes better services, but I wanted to ask you a question which kind of contradicts that notion, because some online surfers embrace the fact that they can get personalized content, but others actually find that creepy because, for example, when they get retire in Spain adverts just because they happened to search for this sort of thing for their mum. So I just wonder whether it's basically a question of relevance. How would you respond in those sorts of situations? Thank you.
Sure. So just very briefly, as we have no time whatsoever, I think in that case, the service is the advertising. The idea of advertising is to give you relevant, which is what we call good advertising. Relevant advertising should be something, ideally, and I know that we're not living in an ideal world, but ideally, you think about, spending your time for your vacation in Spain, and ideally, this is a really nice offer that pops up there. In that business model, where the service is profoundly funded on the fact that advertisings are displayed, this would be a very good outcome. Optimal outcome, because it's individualized and it's relevant for you. It's actually something where you want to click on. Now I know, this is not yet where we are, but the point is, if you want to use a service I'm really cutting this short, if you want to use a service, I guess it's a part of the decision-making process in the beginning. Do I need something? Do I want to pay for something? Do I need this service in that fashion, and am I willing to pay for it? Or do I want this service and I'm willing to accept the fact that I'm presented advertising? That's a very fundamental black and white decision that I guess you have to take in the beginning.
Yeah, I just wanted to link that issue of targeted advertising to the privacy directive, because you're all aware of the cookie law is going to be revised. And so when you are targeted advertising, it's because cookies, tracking, spyware, and so on are being put on your computer, and the approach of the legislator on e-privacy was to say your computer, your phone is like your home, basically. And so a way to make more awareness of what was happening. So when cookies are for added value services, so it's when it's not for the performance of the website, you have this typical cookie banner, which is going to be revised, but the idea is that you are aware that actually, yes, you're going to have your data being given, and so that targeted advertising is happening. And then to come back on the issue of contract, whether they can refuse to provide a service, then we come back to the issue of data anonymization. And as I mentioned, contracts that, it's in the GDPR Article 7, but it was already there. If you want to force the contract based on sharing data that are not necessary for the service, then it's illegal. So then you could imagine an action in court. So it's about fighting the imbalance between individuals and big companies.
So just checking if someone has a really emergent question to trigger here, not to frustrate anymore. So I will give you the floor for the last comment.
Just 1 second. This word of balance, I think is key. I think that when there is the person saying to the computer, I simplify just with the idea, do all what is good for me, computer. This simply means that the person who is asking this doesn't know. And this is a computer, basically a company, who knows instead of the person. I think that in extreme, both ideas are wrong. The companies knowing on the basis of the multiple interactions that there are in the world of data, everything, what the person knows, or the state knowing as a regulator what the person knows. These are two extremes, balance in the middle. I think it's the right response, and checks and balances, as are also in the regulation, are probably, as democracy, the worst system we can imagine, the worst exception made for all the others. Thank you.
So thank you all for attending this panel. I will retain personally that flexibility, sustainability, made all possible by data controllers that would be absolutely accountable, and this is a key question that still remains to determine altogether, is a solution. So thank you so much for all the panelists, and thank you for your questions. Thank you.